So Anne is the PhD researcher in DISSECT, who is working on looking and examining and making sense and whatever else, making sense of the evidence regime of the European Court of Human Rights. So Anne, tell us what your thoughts are at the end of this day.
Thank you, Marie. I will admit that it's a bit of a daunting job after such rich discussions to come in for concluding remarks. My name is Anne, my pronouns are they, them. As Marie said, my project, my PhD project is basically about everything that we have covered today and more, which is why today has been immensely inspiring for me, and I want to thank everyone again for their wonderful contributions. It's a great pleasure to say a few words at the end of what I think was a really thought-provoking webinar, but the presentations were frankly too insightful and our discussions too rich for me to be able to do justice to them if I were to attempt to synthesize them all. So what I'll be attempting to do instead is merely pick out certain themes that we have repeatedly encountered throughout the day. But let me start by acknowledging that there is also a few elements that we haven't looked at. And one in particular comes to mind. Our discussions today really revolved around evidence at the merits stage. We barely touched upon evidence that is necessary to succeed to get one's case to be examined at the at the merits stage. This was briefly acknowledged when we discussed the pushback cases or secret migrant detention. But it deserves acknowledging, I think. There is a tendency amongst academics, and I'm not excluding myself, to zoom in on judgments on the merits, which of course is in part explained by the fact that we often don't have any reasoning in inadmissibility decisions. We could also have an entire conversation about evidence at the just satisfaction stage, especially when it comes to complex cases, say, under property rights under Article 1 of Protocol number 1 to the Convention. But that's just a side note. There is lots more that we have actually addressed today, and let me zoom in on certain things. What I want to do first is repeat that there is very little codification of evidentiary rules and practices. The operation of the court's evidentiary regime can not be assessed in isolation, as we've heard. And Joe gave us this wonderful image of the court's evidentiary regime as a marshland on which it's very difficult to build something solid without a proper foundation. And I think he's absolutely right. As Christine mentioned in her preliminary remarks, the European Court of Human Rights forms no exception to this general rule that international tribunals are usually silent on how they assess evidence, with the exception perhaps of certain criminal courts. So here again, in the convention system as well, the convention and the rules of court are basically silent on how the court is to assess the evidence in cases before it, and in particular on questions relating to the applicable standard of proof and the allocation of the burden of proof. But what we have seen, especially in the enforced disappearance case law that Grażyna highlighted, is that there are a number of adjudicatory tools that the court has developed in its case law. We have Rule 44C1 of the court's rules, which specifically also explains that the court may draw inferences from a party's failure to participate effectively in the Strasbourg court proceedings, which was obviously the part and parcel of Jasmine's presentation. Now, I think the most detailed procedural provisions in the court's rules pertain to investigatory measures, and that leads us to looking at the evolution of the court's evidentiary regime. I think that too is sometimes useful to delve a bit into history to make sense of what we see today. It has been mentioned that the court has moved away from a very active fact-finding position that was usually was assumed mostly by the European Commission before the entry into force of Protocol number 11 in 1998 that abolished the Commission. And the new court never really assumed the role of such an active fact finder. And I think we could have an entire separate discussion about what the precise implications are. Are the adjudicatory tools that it has developed, the shifting of the burden of proof, for instance, sufficient and adequate to make up for the fact that no active fact finding in situ is commonly used these days? There is also a second element that I want to zoom in on, and that's the link between evidence and broader principles of operation of the court. That's another dimension to show that the court's evidentiary framework does not operate in a limbo, I think. It's linked to broader principles that the court adheres to. And obviously the first one that comes to mind, and we discussed it repeatedly throughout the day, was the principle of subsidiarity and how it makes the court reluctant to question the domestic court's findings of fact. And we have seen this play out differently in different case clusters. During the discussion of Christine's presentation, for instance, it emerged that in the discrimination context, the court will not only be extremely differential to domestic courts' factual findings, but it even seems that the chances of having one's discrimination claim heard at all in Strasbourg depends on how the domestic courts have treated that discrimination claim. Nele, in her presentation, asked if there might be an over-reliance on the procedural issue in the environmental degradation case law and climate change litigation. Is the court simply rubber stamping domestic decisions, she asked. And Grażyna identified a related obstacle in perhaps the future case law on secret migrant detention. She reminded us that no one asks for the migrants or about their fate. So no one is approaching the domestic authorities to try and produce evidence. And that then leads us to a discussion, and we have touched upon this, of the extent to which the court should be proactive in soliciting expert evidence or other types of evidence. And this is also one question that I've been asking myself. Is the court always in a well-positioned to grapple with evidentiary uncertainty itself, or should it try to boost its own expertise, for instance, through training on? But I'll come back to that in a moment when I zoom in a little bit on different sources of evidence. Let me open a quick parenthesis while we're talking about the context that needs to be borne in mind when we assess evidentiary questions, and that is a hypothesis that I'm following in my own work. I find it difficult to imagine that evidence can exist and be analyzed without also looking at case management questions. We are dealing with a court that is overwhelmed still by a huge number of cases, that has sophisticated rules of procedure. It has a very clear but developing hierarchy or case prioritization policy, etc. And I, in my own work, want to try and find out how the court brings that together, or how that is interlinked with evidentiary questions. How, for instance, does the court deal with a case such as Georgia and Russia #2, where we have 30,000 pages of documents? I briefly earlier talked about the evolution of certain evidentiary rules and practices. And one thing that is quite remarkable is that sometimes the court develops a precedent focusing on evidentiary questions and says clearly why it is doing so. I have in mind, for instance, the beyond reasonable doubt standard, the justification delivered by or presented by the European Court of Human Rights for the beyond reasonable doubt standard is that it takes account of the seriousness attached to the finding of a convention violation. Or in the enforced disappearance case law and extraordinary rendition case law, the court explicitly recognizes that the victims or their next of kin will not usually have access to evidence. And that is why there ought to be a shift of the burden of proof once prima facie evidence has been established. But at other times, I feel like we're sort of left speculating about the precise rationale for certain evidentiary practices. And this element of speculation is also something that came up throughout the day. It also pertains to analyzing specific judgments. Why was the outcome, was it what it was in a specific judgment? And this is perhaps somewhat unsatisfying situation. Both Joe and Kristin have expressed criticism about the fact that the court tends to merely restate its evidentiary principles, but then not necessarily explicitly apply them step by step with explanations to the case at hand. And Nele said that where the threshold of Article 3 was not reached in certain environmental cases, we are also left wondering why, or what would have allowed the court to find that the threshold had been reached. So this element of speculation, if I may put it like this, is something that we all grapple with, looking at the court's practice from the outside. And it also shows that more empirical studies, such as Nele's, are really, really important. I really hope, Nele, that you will be able to elucidate to what extent your early findings, which suggest that the court is more prepared to accept domestic reports than international reports, are valid. So this grappling with contradicting evidence is something that really asks for or calls for a zooming in on specific cases that ought to be dissected properly, I think. We've established that the proceedings before the European Court of Human Rights are predominantly adversarial, but with sort of a dash of inquisitorial flavor, if I may put it like that. In practice, the proceedings are very much party-driven and also based on exchanges of written documents. Again, I think we could have a whole discussion about what it means that there are very few fact-finding hearings, and what it means that these fact-finding hearings, where they do happen, are behind closed doors, unlike in the practice of the Inter-American Court, for instance. Jasmine reminded us of the obligation to furnish necessary information and everything that is attached to the court's power to demand certain materials. And at the same time, we've also seen that the court itself is, in a way, creating evidence notably of patterns and systemic violations. We had a very lively debate about the threshold that ought to be reached before we can talk about domestic violence as gender-based discrimination, for instance. Both here and in the context of Article 18, the court uses its previous case law to then later on find that there is such a practice. And I think that is really one point worth highlighting. A big heading in my notes for these concluding remarks reads flexibility versus predictability. We have talked a lot about flexibility, also consistency or inconsistency, and how these values are sometimes opposed to each other and a balance ought to be struck between them. Just now we talked about security guarantees and in the national security context, for instance, there is an expectation then on the part of states that the court will accommodate its demands on keeping things secret, for instance. I said that the court's evidentiary approach has developed over many decades, and it continues to develop. Kristin, Katarzyna, Nele, Joe's presentations, they all showed how fluid the development is, and perhaps also how fragile certain advancements in the evidentiary rules and practices might be. Is there a risk that certain principles might be rolled back in the future? Kristin said that different sections might have different approaches. That would definitely raise a big question of consistency, in my view, which would then also which we could also pose in relation to other issues. We talked, for instance, about the large-scale structural bias that has been shown. Once that has been shown to exist, the applicant does not necessarily need to prove that she was also a victim of individual prejudice. We talked about that in the domestic violence context. But we don't see the same standard in racial discrimination cases. In direct racial discrimination cases, we have now understood that it's way more difficult to link, for instance, statistics of Roma people being disproportionately affected by police violence to an individual case brought by an individual applicant. So again, it's really interesting to bring together those presentations that focus on specific provisions of the court. We do tend to see, I think, a certain inconsistency in how evidence is treated. One more area, broader area that we addressed today that I found extremely interesting, and I will try to grapple with moving forward in my own project, is the issue of causality. Nele, in particular, in her presentation, talked about impossible proof. There were calls for a different approach to causality, maybe the absence of any other discernible cause for an applicant's asthma, for instance, should be the one possible way for a government to refute an allegation that there is a causal link between environmental protection, lack thereof, and harm caused to the individual. In the context of Article 18, and I found this very, very interesting, we had different calls in a way. Joe said that maybe the abandonment of the predominant purpose test would be something desirable. Maybe the predominant purpose test could be abandoned in favor of adopting an approach that exactly centers around causality. So again, causality can play out very, very differently, potentially, in different thematic contexts. One big area that every single presentation has looked at is different types of evidence. We just come out of a very fruitful and very engaged discussion about circumstantial evidence in the national security context, but it was also mentioned in the Article 18 context, for instance. We have discussed the impact of international standards and comparative international law. We saw that Council of Europe instruments such as the Council of Europe, the Istanbul Convention, and the work of Grevio, the body supervising the implementation of the Istanbul Convention, seems to have a very high standard of credibility and authority in the eyes of the court as a Council of Europe internal body in a way. Credibility of sources was highlighted to be a very key element. We heard from a court insider, a former court insider, that judges really argue about how credible a specific source is. And I think in these times with deep fakes floating around on the internet, this element will only become more relevant, if anything. We have looked at very novel forms of trying to bolster one's claims, substantiate one's claims. We looked at satellite imagery, for instance. Grażyna mentioned the forensic architecture project that allowed for a reconstruction of events at the border between Turkey and Greece, and the use of satellite data derived from WhatsApp messages. This is something that we can obviously never have imagined at the inception of the convention system. And a legitimate, it's a legitimate, I think we can ask a legitimate question about how well prepared the court is. It is composed of legal experts, after all, of dealing with these novel forms of evidence. When talking about types of evidence, I think there is one other area that is worth addressing, and that is presumptions. Presumptions, we just learned again from Jasmine, are would usually benefit the applicant. One point that one could have made is, or Jasmine's presentation talked about the understanding that domestic courts are better placed to assess the necessity to restrict access to certain documents for national security reasons, for instance. But the court will enter into a review if the domestic court is arbitrary, or domestic law is arbitrary or manifestly unreasonable, for instance. So this good faith presumption is rebuttable. But presumptions have to do a lot with trust, I guess. Whom does the court give the benefit of the doubts if it becomes relevant to really weigh these issues? This came up very clearly when Nele spoke about contradictory evidence, as I mentioned a moment ago, in environmental cases, and the apparent preference of the court to accept government-sponsored or government-commissioned expert reports over international materials is certainly something that is noteworthy. So we look forward to Nele's research findings and to see if a more holistic review of the case law substantiates this initial hint. The convention system as a whole obviously rests on the assumption that states engage in proceedings before the court in good faith. So to me, it really would appear that this presumption is sort of the glue that holds the convention system together. And then there's no other area, I think, where the clash between this vision and reality can become more apparent than in relation to the court's bad faith case law under Article 18, which Joe has elucidated in such great detail. And here, I think it's really interesting to see that there has been a great evolution. We are no longer left with a situation where applicants are required to submit themselves direct proof of an ulterior purpose. And I think that's a very, very positive development indeed. Despite the marshland style layout of the evidentiary regime, these developments still seem possible. And I think that should fill us with a sense of optimism. I think I'm already going to wrap up in the interest of time. Permit me two more comments. The first is still sticking with presumptions. One element that I was thinking about when we had our discussion about migrant detention with Grażyna was that in the traditional migrant detention case law, I'm thinking about detention for the purposes of effectuating an expulsion or a deportation, there is a presumption in the court's case law that detention is harmful, especially to children who are in immigration detention, for instance. But there are certain other presumptions that you could make that are perhaps more problematic. I remember, or I just recently read a contribution by Ghent University's very own Professor Eva Brems, who has identified, for instance, that in the Islamic headscarf ban cases, the court has accepted verifiable claims by governments without any evidence of critical scrutiny. For instance, that a headscarf worn by a teacher might interfere with the freedom of conscience of her pupils, or that the claim that the removal of a headscarf is necessary to conduct a security check. So in a way, there are certain presumptions that are just, or certain facts that don't need to be proven. And that to me is a fascinating area that really calls for a more holistic examination. The big question, the overarching question that I see arising from today's proceedings is, well, what do we want actually? What would an ideal evidentiary system look like? Against which normative ideals should the court's treatment of evidence be measured? The court itself is fairly quiet on that. We have more time allocated for a general discussion, and maybe that big normative question is one that we might want to address. And with that, I can only leave you with a few final words, and perhaps also end on a personal note, if you permit me. As I said, I leave this webinar really, really inspired. Thank you for 6 fantastic presentations covering such a wide range of evidentiary topics. Thank you for stimulating discussions and really thought-provoking questions, which I think will all stay with us, will stay with us all for a while longer. But I don't only feel intellectually stimulated, to be honest, but I also feel emotionally uplifted, if I may put it like this. And this is because I think the one thing that tied us all together here today was our common belief, our common conviction that issues relating to proof and evidence in proceedings before the European Court of Human Rights and beyond deserve greater attention. Taking and assessing evidence is an essential judicial function of international human rights tribunals, and fact-finding really constitutes a fundamental aspect of the delivery of justice for potentially millions of people, to borrow the words of Philip Leach. And with that, I say thank you, and I look forward to a big wrapping up discussion.
I have to applaud, you know, not just on my electronic hand, because you know, of course I knew you were going to wrap up in an amazing manner, but even though I knew that, you still kind of go beyond my expectation. Well, maybe I should not say that, because then it would mean I expected less, and of course I did not. But what I want to say is, first of all, I mean, this is a tour de force, to bring in all these different contributions together as you have done. Now, you have proposed one big question: what kind of evidentiary regime would we want the European Court of Human Rights to have, if it's a little bit different from what exists now? So in other words, how could it be improved? Do we think it could be improved? So that's one possible line of going together, if anyone wants to say anything. I mean, yeah, I don't know if anybody wants to talk. To me, what I really keep from this day is that I really think that comparative work from within different areas of the court's case law is, to me, is highly needed. I cannot quite believe that everything is consistent from one area to the other, and that the way we use words, the way we apply rules or norms or principles do not always resonate in the same way. And to me, I find that fascinating.